I tried to negotiate with Mr. Porter, Your Honor. We are trying to do this between us, not him and the attorney. She
Can't,
really is disconnected between a lot
can't,
of it.
can't, Miss Kearns. You
There's no negotiating then, so I
can't.
guess.
Here it is. Sorry about that.
No worries.
Ms. Van Dyken joins us again. Ms. Van Dyken, good morning.
Good morning, Your Honor.
And Ms. Van Dyken appears, let me just make sure, appears on behalf of the plaintiff, Travis Porter. Mr. Porter, good morning to you.
Good morning.
And the defendant appears, Ms. Kaylee Kearns. Ms. Kearns, good morning to you.
Good morning, sir.
I have read your motion, Ms. Kearns, and I take it you have seen that as well, Ms. Van Dyken?
I have, Your Honor.
Thank you. And you received Ms. Van Dyken's response, Ms. Kearns?
That is correct.
Okay. Anything you want to add to your motion before we hear from Ms. Van Dyken?
Yes, sir. I just want to kind of give you a little bit of since this has all happened until today. Travis is doing exceptionally well since filing this paperwork. He is getting work. He is getting job. He has moved his bedroom out of Olive's room, which was something that we have discussed over and over again. So a lot of these things, he's making strides, which is great improvement. I support that. That's all I want, is to support Travis in being a better father for our child. We have not had anything established with the courts yet. So this is kind of step one to get something written to, with these conditions and everything that has transpired. We have been pretty much verbal, and we co-parent very well for the sake of our child. We don't have issues on many things. However, it was brought to light what was happening when I filed this paperwork. I filed it shortly after I found out what was actually happening at his household. And I am a stable parent. I always have been. Travis leans a lot on his parents, which I know you've read that in my motion. And the concerning factor is I need to make sure that moving forward, Travis is on pace with getting better, getting help, getting a job, becoming stable on his own, not so much his parents' help. I need to co-parent with him and not his parents.
Well, let me ask you this.
Yes.
Because it seems that probably the better approach, in my view, since you now have Mr. Porter being represented by a very able attorney, is to send each other proposals and see if you...
All right, everyone. Today's courtroom hearing begins with an immediate disagreement over whether meaningful negotiations ever took place before the matter reached the judge. As the session opens, one party argues that every effort was made to resolve the dispute privately, while the opposing side insists communication had completely broken down. Within moments, the courtroom shifts from routine introductions to a deeper discussion about trust, legal representation, and whether both parents genuinely attempted to work together before asking the court to intervene in their ongoing custody dispute. With everyone formally identified, the judge confirms that all motions and responses have been reviewed before inviting additional comments. Rather than focusing only on legal arguments, the discussion quickly turns toward recent developments in the father's personal circumstances. Kaylee Kearns explains that several positive changes have taken place since the paperwork was filed, describing improvements in employment, living arrangements, and personal responsibility. She makes it clear that her objective is not punishment, but encouraging continued progress while protecting the long-term interests of their child. As the hearing continues, Kearns explains that the parents have managed many parenting decisions through verbal agreements despite never having a formal court order in place. She acknowledges that co-parenting has generally worked well, but argues that recent discoveries raise concerns serious enough to require legal involvement. According to her statements, the filing was prompted by developments inside the father's household that she believed required greater oversight. Throughout her explanation, she repeatedly emphasizes that stability and consistency remain her highest priorities for their child's future. Building on those concerns, Carnes tells the court she considers herself the more stable parent while expressing concern that Travis Porter continues relying heavily on his own parents for support. She explains that her goal is to see him become independently responsible through stable employment and continued personal improvement rather than depending on extended family. In her view, successful co-parenting requires direct cooperation between both parents. She stresses that future decisions should reflect each parent's individual ability to provide consistent care and responsible decision-making for their child. After listening carefully, the judge shifts the discussion toward finding a practical solution instead of allowing the conflict to become a lengthy courtroom battle. He notes that Travis Porter is now represented by legal counsel, making structured negotiations a more appropriate path forward. Rather than immediately ruling on every disputed issue, the judge encourages both sides to exchange written proposals through proper legal channels. His comments suggest that compromise may resolve many disagreements more efficiently than prolonged litigation, reducing both financial costs and unnecessary conflict. The conversation then turns to communication between the two sides. When the judge asks whether meaningful discussions have taken place, it becomes clear that direct contact has been limited since legal representation entered the case. Recognizing the growing communication gap, the judge encourages renewed efforts to negotiate before moving deeper into formal court proceedings. His message is straightforward. Several requests from both parties appear reasonable, and a carefully drafted written agreement could resolve significant portions of the dispute without requiring a prolonged legal battle.
You two can agree on
That did happen, Your Honor.
Okay. I mean, Ms. Van Dyken, have you and Ms. Kearns communicated at all?
No, Your Honor.
I didn't think so. He has an attorney on the case now, Ms. Kearns.
Yes.
I would like to give Ms. Van Dyken the opportunity to try and work towards a resolution of this before we start getting into long, drawn-out, expensive court matters. Because it sounds like to me some of the things you've asked for in the motion are reasonable. Some of the things that Ms. Van Dyken has pointed out are reasonable. It would make imminent sense to me, anyway, to adjourn this motion without date and have you and Ms. Van Dyken exchange some possible proposals and see if you two can't come to some agreement on paper in writing so that
Your Honor, I'm so sorry. That did happen. She sent me a DocuSign a few days ago and I did not sign it because we did not communicate at all. She tried to have me sign something for joint everything down the middle. And with his condition, he is not able to make those decisions right now. So
okay,
that is
hang on. Stop talking, please. Now I'm
okay.
confused now. Ms.
Okay.
Van Dyken, have you had conversations with Ms. Kearns?
I've not had conversations, Your Honor. My client had told me that they spoke and they had an agreement. I put that into a stipulated order and sent it to Ms. Kearns. Obviously, she didn't agree with it, and whatever they were communicating wasn't clear. But I understand this court's wanting to adjourn this, but we need something to be followed. This can't be a unilateral decision made by Ms. Kearns.
Well, I mean, obviously, I'm not going to cut off parenting time. I don't have a problem if his parents supervise, at least for the time being. But as you know, I can't make these decisions on a Friday morning. This is going to be sent to the front of the court. And then you're going to be right smack dab in the place you are before. So I'm trying to look for something to short circuit this. And it would have been a little more productive, Ms. Kearns, if you simply would have, and I don't know if you have, maybe you did, if you simply would have written to Ms. Van Dyken and say, okay, I've got this. These are the things I'm okay with. This is something I'm not okay with. And that's what negotiation is, right? I mean, you just can't, negotiation is not someone sends you something, you refuse to sign it, and then everybody goes their separate ways, right?
I tried to negotiate with Mr. Porter, Your Honor.
All right, everyone, this is where the hearing takes a more revealing turn. The judge asks a straightforward question about whether meaningful communication has taken place between the parties since legal counsel became involved. The response highlights a growing disconnect, prompting the court to encourage another attempt at resolving the dispute outside a prolonged legal battle. Rather than rushing toward a contested hearing, the judge emphasizes that written proposals and open communication could save both parents considerable time, expense, and emotional strain while keeping the child's interests at the center. As the discussion continues, the judge explains that several requests presented by each side appear reasonable and could potentially be resolved through compromise. Before any formal rulings are made, he recommends exchanging detailed written proposals to determine whether common ground still exists. At that point, Carnes tells the court she received a document through DocuSign, but chose not to sign it because, in her view, there had been little direct communication explaining its terms. She also expresses concern about provisions involving shared legal decision-making. The plaintiff's attorney responds by explaining that her understanding was very different. According to her, Travis Porter believed both parents had already discussed the issues and reached an agreement, leading her office to prepare a stipulated order reflecting those conversations. However, when Carnes declined to sign the document, it became apparent that both sides had interpreted their previous discussions differently. The attorney acknowledges the court's preference for negotiation, but stresses that any temporary arrangement should be based on mutual agreement rather than one parent's unilateral decisions. Listening carefully to both explanations, the judge makes it clear that parenting time should not be interrupted without sufficient legal grounds. He indicates that temporary supervision by the father's parents is not necessarily a concern, while broader custody issues remain unresolved. At the same time, he explains that major decisions cannot be made immediately during a routine hearing. Instead, the matter will likely proceed through the appropriate family court process, allowing additional review before any long-term custody determinations are finalized. The judge continues by explaining that productive negotiation requires more than simply accepting or rejecting paperwork. He suggests that a written response outlining which proposals are acceptable and which require modification would have created a stronger foundation for compromise. In his view, successful negotiations depend on continued dialogue rather than silence after receiving legal documents. His comments reflect the court's broader goal of encouraging cooperation whenever possible before committing both parents to a lengthy and potentially expensive custody dispute. As the discussion circles back to the negotiation process, Carnes maintains that she attempted to resolve matters directly with Travis Porter instead of communicating solely through attorneys. She argues that misunderstandings continued because, from her perspective, important conversations were becoming disconnected once legal representatives became involved. After hearing both positions, the judge concludes that informal negotiations have reached an impasse. With no immediate agreement in sight, he signals that the case will now move forward through the formal court system so unresolved legal questions can receive a structured review.
We are trying to do this between us, not him and the attorney. She really is disconnected between a lot of it.
Can't, Ms. Kearns.
There's no negotiating then, so I guess we have to send it to the front of the court.
Okay. Then that's where it's going to go, and the fee for that's $300, and you're responsible for that, Ms. Kearns. And that's what I'll do because clearly the judgment of support was entered, and what I take it, Ms. Van Dyken, since this is a Sims versus Berrugi matter, you'd be requesting that this court refer it also on legal custody. Is that accurate?
That is accurate, Your Honor.
Okay. I'll do it. There's a lot better ways to do this than this, but I got to do something. So I will complete the order of reference. And if the parties, I will tell you this, if the parties have verbally agreed to a parenting time schedule, I want that schedule followed until we come back into court. unless that's now an issue.
Your Honor, I'm so sorry.
You're chatty, Ms. Kearns. Very chatty. Go ahead.
Me and him are in agreements of parenting time. We are not in agreements of legal custody. That is the only thing that we have not been in agreements of. And I'm not trying to be a chatty Cathy. I'm just trying to make sure you understand where we're at with this.
So the parenting time is fine, Ms. Van Dyken. We just need legal custody taken care of.
And I guess I want to clarify, is the parenting time fine as to what I put in my stipulated order as a 2-2-3 schedule? That's in my stipulated order.
I'd have to review the order more detailed before I put it on record. I'd like more time, but essentially, yes, what we've been doing is what Travis told me. That's what he told you. So that's what we agreed on as far as parenting time, but just the legal part of things because he cannot make decisions. Okay.
I get it. So I'm going to ask Ms. Van Dyken to resend via DocuSign the order, but leave out the legal custody, and I will send that to the friend of the court, and they can chew on that and see if that's appropriate. That way, we get something started now, and that way the parties know where they stand, and then we can take care of it that way. But it's a good point. I get it, Ms. Kearns. Legal custody is a big step, but we'll see what the friend of the court has to say about that, and come back, and I'll have Ms. Van Dyken prep the order that has everything in it as previously except the legal custody, and I'll do the order of reference on that. Okay?
Thank you, Honor. I'll send that over to you.
Thank you. Ms. Kearns, Mr. Porter, I wish you both the best of luck, okay?
Okay.
Yep.
Thank you.
All right, everyone. The courtroom reaches a turning point as the judge concludes that further informal discussions are no longer producing results. With both sides standing by their positions, he explains that the matter will now move through the formal family court process. Administrative fees and procedural requirements are addressed before the conversation shifts toward the remaining legal questions. Rather than extending the debate, the judge focuses on establishing a clear path forward so the unresolved custody issues can receive a thorough and structured review. Attention then turns to legal custody. The judge asks the plaintiff's attorney whether she is requesting that the issue also be referred for additional review, and she confirms that request. Although he remarks that there are better ways to resolve these disagreements, the judge explains that formal intervention has become necessary under the circumstances. He prepares the required order of reference while encouraging both parents to continue cooperating wherever possible, reminding everyone that reducing conflict remains beneficial for both the family and the court. Before concluding this portion of the hearing, the judge addresses parenting time separately from legal custody. He instructs both parties to continue following the parenting schedule they have already been observing until the court issues further guidance. During the exchange, Carnes attempts to clarify an important distinction, prompting the judge to comment on her eagerness to speak before allowing her to finish. Despite the brief interruption, the discussion remains focused on identifying exactly which issues still require the court's attention. Carnes explains that parenting time itself has not been the source of disagreement. According to her, both parents have generally remained on the same page regarding visitation arrangements, while the unresolved dispute centers solely on legal custody and major decision-making authority. She emphasizes that her intention is simply to ensure the court fully understands the current situation. The judge acknowledges her clarification, recognizing that separating parenting time from legal custody may help narrow the issues requiring future judicial review. The conversation then shifts toward a practical temporary solution. The judge asks that the proposed parenting order be resent without any provisions addressing legal custody. By separating those issues, he hopes both parents can immediately operate under a written parenting schedule while leaving the more complex legal custody questions for later consideration. This approach allows the family to establish greater stability in the short term, while giving the appropriate court officials additional time to evaluate the remaining areas of disagreement. As the hearing draws to a close, the judge reiterates that legal custody is a significant issue deserving careful review before any final decision is reached. He directs that a revised order be prepared reflecting the temporary parenting arrangements while excluding unresolved custody provisions. With those instructions entered into the record, both parties acknowledge the court's guidance, and the hearing concludes on a respectful note. Although many questions remain unanswered, the next phase of the custody process will now proceed through the appropriate legal channels.